Hi, I'm Matt Joyner, and this is the fifth of our five-part series on demystifying your deal. So far we've talked about the preliminaries of the deal, the purchase agreement, seller's issues, third-party issues, and now we finally talk about the closing. Okay, so you finally gotten your deal to closing. Congratulations. This is the big moment. Now what can you expect in the closing? Traditionally, people think about a closing with everybody involved sitting around the same table in one conference room, signing all the documents and the money changing hands, and there's a celebration. That can still happen, but more frequently what happens is there's a remote closing where the buyers in their lawyer's office in one place, the sellers in their lawyer's office in another place, the parties execute the documents in their respective lawyers' offices, email them to each other, and then later courier the originals of those documents to each other. So often the parties now are not actually in the same room at the same time for the closing. At the closing, there will be some ancillary documents to the purchase agreement that deal with the actual consummation of the deal itself. First, there'll be authorizations by the parties. Now, conceptually, this is something that takes place at the beginning, but you typically don't see that document until the closing itself, where both the buyers, owners, and managers, and the sellers, owners, and managers issue resolutions authorizing the officer of that company to sign the documents in the deal so that nobody can come up after the closing and claim that there was something wrong with the deal because people who were supposed to be consulted were not. If the deal is what we call a delayed closing deal, typically there will be certificates by the seller's management to the effect that all of the representations and warranties of the seller that were in the purchase agreement back when the purchase agreement was signed are still true and accurate as of the date of the delayed closing. Again, not a lengthy document, but one that reassures the buyer that nothing strange has happened between the signing of the purchase agreement and the actual closing. Another very important document that will show up at the closing is the actual bill of sale. The bill of sale is the document that actually transfers the legal title to the thing being purchased. It's typically not a lengthy document, but it's an important document because that is the actual document that transfers the title, which after all was the objective of the entire exercise. The last and probably most important document at the closing is the closing statement itself. The closing statement sets out in outline form the flow of the funds in the deal. It'll show the purchase price, whether the seller is having any of its expenses paid out of the purchase price, and how much cash is actually due the seller at the closing. From the buyer's side, it will show the purchase price, how many additional expenses the buyer needs to cover in the closing on top of the purchase price, and how much cash the buyer has to bring to the closing. The closing statement will then show the receipts of the money into a bank account, either the lawyer's trust account or someplace else, and the disbursements of those funds, who they will be dispersed to, in what amount, and by what means, either check or wire. Finally, if there is a wire transfer out of the attorney's trust account, there will be a certification by the parties that yes, the closing statement does reflect accurately the intended flow of monies in the deal, and that the closing attorney has the authority of the parties to receive those funds and disperse them according to the closing statement. As you can see, the closing statement is a very important document. After the parties have spent so much time and energy negotiating and bringing to a closing the purchase agreement, when you get down to it, it's about the transfer of the money, and everybody's interested in that. And the closing statement is the thing that accomplishes that very important piece of the deal. Now, you would think that once you've had a closing, that's the end of it. But no, there are going to be post-closing matters for the parties to attend to. For instance, to the extent the seller has had liens on any assets being sold, the attorney will be involved in getting the seller's lenders to remove their liens, typically their UCC filings, from the public record. That typically happens after the closing, once the lender has been paid off. If there are vehicles being sold in the transaction, typically the titles to the vehicles will be transferred with the DMV after the closing. To the extent Any funds in the deal have been put in escrow with a third party for payment at a later date. That also ensures that there will be involvement by the attorneys later on with regard to this ongoing piece of the deal. And finally, as we talked about in a previous video, to the extent there is inventory to be valued, working capital to be valued, there will be an adjustment mechanism post-closing after the buyer has gotten into the business and seen whether the inventory levels or the working capital levels are where the parties agreed they would be as of closing. So once you've gotten to the closing, you've come a long way. You finally have the bill of sale transferring title and the closing agreement moving the money. At this point, we've gotten the deal over the goal line and everybody's happy. I'm Matt Joyner. Thanks for watching.
If you need legal advice for your business in North Carolina, call Matt, send him an email, or connect with him on LinkedIn.